The February ruling detonated a legal bomb under gun control infrastructure. Nobody's discussing the constitutional crisis brewing in 3 states or the $4.2 billion industry shift happening right now. Hit subscribe immediately. This intel could mean the difference between exercising your rights and losing them forever. Law 1. Interstate carry enforcement chaos. The state-by-state enforcement nightmare for constitutional carry just turned into a war between local police and federal courts. And officers on the ground are completely unprepared for what's legal. A Mississippi resident with constitutional carry in his home state flew to New Jersey with his pistol declared and locked in checked baggage, completely legal under federal FOPA protections. His connecting flight got canceled, is forcing him to spend the night in New Jersey. Airport security discovered his firearm during a random bag check the next morning. New Jersey arrested him for unlawful possession. He spent $34,000 in legal fees over 14 months before federal courts intervened based on the February ruling. The enforcement crisis is real. 23 states with permit requirements have not updated their arrest protocols. Police officers in these states are still being trained under old laws that criminalized out-of-state constitutional carry. Training academies in California, New York, and New Jersey have openly stated they will not modify their curriculum until their state legislatures explicitly change state statutes, something that hasn't happened. This means lawful carriers traveling through these states are being arrested by officers following outdated training while courts simultaneously rule those arrests unconstitutional. Law 2. Red flag legal standard revolution. The due process requirements inserted into red flag laws just created a massive split between how psychiatrists, judges, and law enforcement define dangerous, and the courtroom battles are exposing how flimsy the evidence standards were all along. A California software engineer posted photos of his new rifle collection on Instagram with the caption, "Ready for anything." A former colleague who'd been fired from the same company filed a red flag petition claiming the posts were threatening and indicated preparation for violence. The judge issued the order in 8 minutes without examining the posts or asking what specific threat existed. The engineer lost access to $11,400 worth of firearms for 11 months. The February ruling forces judges to apply the same evidentiary standards used in other civil proceedings where constitutional rights are at stake. Petitioners must now provide specific behaviors indicating imminent risk, corroborating evidence beyond personal opinion, and demonstration that less restrictive interventions were considered or attempted. In Washington state, 47% of red flag petitions filed in March 2025 were dismissed at initial hearings under the new standards, compared to a 4% dismissal rate in March 2024. In Maryland, the average hearing length jumped from 12 minutes to 78 minutes, because respondents now have attorneys present who cross-examine petitioners. Have you or anyone you know ever been close to having a red flag petition filed against them? And what would have happened under the old versus new standards? Law 3. Homemade firearm industry explosion. The restoration of privately made firearm rights didn't just unban 80% frames. It triggered a complete manufacturing revolution where small machine shops are now legally competing with major gun manufacturers. And the economic disruption is reshaping the entire industry. A former automotive machinist in Texas started a company selling 80% AR-15 frames with jigs and instruction videos. Within 90 days, he had 4,200 orders and hired 14 employees. His gross revenue hit $1.8 million in the first 4 months. The big manufacturers are panicking because they can't compete on price with home manufacturing. An AR-15 from a major brand costs $800 to $1,200 retail. Building one from an 80% frame costs $420 to $580 in parts, and the quality is identical because builders are using the same mil-spec components. Industry analysts project that privately made firearms could capture 18 to 22% of the rifle market within 24 months. The ripple effects are massive. Tool and die companies are expanding to handle demand for jigs and fixtures. CNC machine manufacturers are creating gunsmith packages for hobbyists. And YouTube channels teaching firearms manufacturing are exploding. One channel went from 18,000 subscribers to 340,000 in 5 months. Law 4. Magazine capacity. Criminal justice reversal. The magazine ban collapse didn't just legalize standard capacity magazines. It instantly converted 127,000 people with active criminal convictions into individuals wrongfully prosecuted under unconstitutional laws, and the expungement crisis is overwhelming state courts. A college student in New Jersey inherited his grandfather's gun collection in 2021, including a Glock 17 with 3 factory 17-round magazines. He didn't know the magazines were illegal. Police found them during a traffic stop in 2022. He pleaded guilty to avoid trial, paid $2,400 in fines, and served 60 days in county jail on weekends. The February ruling makes his conviction unconstitutional. He filed for expungement and faced an 8-month backlog because New Jersey courts received over 8,400 similar petitions in the first 45 days after the ruling. The State Attorney General's office is fighting every single petition, arguing that people who pleaded guilty accepted responsibility for breaking the law as it existed at the time, even though that law is now unconstitutional. California is facing a class action lawsuit from 34,000 individuals who paid fines, served jail time, or accepted probation for magazine possession. The lawsuit seeks $890 million in compensation for unconstitutional prosecution. Law 5. Suppressor market transformation. Suppressors moving out of the National Firearms Act didn't just speed up purchases, it detonated a $4.2 billion market expansion that's transforming firearms manufacturing, retail, and even shooting range design across America. Before February, suppressors were boutique items. The $200 tax stamp, 10-month wait, and regulatory paperwork kept ownership at 2.9 million units across 120 million gun owners, a 2.4% adoption rate. Silencer Co., the largest suppressor manufacturer, received 41,000 orders in the first week after the ruling. Their entire 2024 production volume was 38,000 units. They're now operating 3 shifts, hired 340 new employees, and built a second manufacturing facility. Smaller manufacturers are experiencing 300 to 700% order increases and can't scale fast enough. Lead times that were 2 to 4 weeks before February are now 16 to 22 weeks because raw materials suppliers can't keep up. The suppressor industry is projected to hit $1.8 billion in revenue by December 2025. That's 650% growth in 1 year. Shooting ranges are redesigning their facilities because suppressed fire is quiet enough to allow multiple shooters in closer proximity, increasing capacity. And hunters are buying suppressors at rates that shocked wildlife agencies. Washington State's Department of Fish and Wildlife reported that 34% of deer hunters used suppressors during fall 2025 season, compared to 4% in 2024. The hearing protection benefit is real and documented. Audiologists are reporting 67% fewer cases of noise-induced hearing loss among recreational shooters in states tracking the data. Would you buy a suppressor now that you don't need a tax stamp and 10-month wait? And what would you use it for? Law 6. Family transfer inheritance protection. Private sale deregulation didn't just eliminate transfer paperwork. It restored the ability of families to pass down firearms as heirlooms across generations without government intervention. And the cultural impact is as significant as the legal change. A Wyoming rancher died in 2023, leaving 23 firearms to his 3 adult children in his will. Under Wyoming law, the transfers were legal. But one child lived in Colorado, which required all transfers to go through a dealer. The Colorado resident had to drive to Wyoming, transport his inherited firearms to a Colorado dealer, and pay $35 per gun, $805 total, To receive property, his father explicitly left him. The dealer refused to transfer 3 rifles because they had features Colorado classified as assault weapon characteristics, even though the rifles were over 40 years old and had been in the family since 1981. The son had to sell them at Wyoming prices and accept $1,800 for 3 rifles worth $3,200 in Colorado. The February ruling eliminates this entirely. Families can now pass firearms through generations without government involvement, without fees, and without creating databases of who owns what. The cultural restoration is profound. Firearms as family heirlooms, passed from grandfather to grandson, from mother to daughter, are protected as the constitutional tradition they've always been. Gun rights advocates call this the most significant victory for family rights in decades, because it removes government intrusion into private family decisions. Law 7. Assault weapon, ban enforcement collapse. The assault weapon definition narrowing didn't just unban certain rifles. It created instant legal chaos where state police in 9 states are holding thousands of confiscated firearms they can no longer legally keep, and district attorneys are dropping prosecutions mid-trial. New York's SAFE Act required registration of assault weapons, and 44,000 firearms were registered between 2013 and 2024. When the February ruling struck down feature-based bans, every one of those registrations became legally meaningless. A Rochester resident registered his AR-15 in 2014 under the SAFE Act. In 2023, he moved to Pennsylvania and requested his rifle be transferred to his new address. New York State Police denied the transfer, claiming the rifle was still subject to New York's assault weapon restrictions, even though he no longer lived there. The case was pending when the February ruling came down. The court ordered New York to immediately return his property and pay his legal fees, $8,700. New York is fighting 1,847 similar cases where registered firearms were seized, sold, or destroyed under laws now ruled unconstitutional. The evidence room crisis is real. Connecticut State Police are storing 4,200 rifles seized as assault weapons that are now legal to own. The state can't return the guns without checking if the owners are still legally allowed to possess firearms, but they also can't keep the guns because the original basis for seizure is unconstitutional. Some firearms have been in evidence rooms for 9 years. Law 8. Vehicle Self-Defense Justification Expansion. Castle Doctrine vehicle extensions didn't just remove duty to retreat. They fundamentally transformed how prosecutors evaluate self-defense shootings in cars. And the shift is causing district attorneys to decline prosecution in cases they would have aggressively pursued 18 months ago. A rideshare driver in Philadelphia picked up a passenger at 2 a.m. who pulled a knife and demanded money. The driver drew his licensed, concealed carry pistol and shot the passenger when the man lunged at him. The passenger survived. The district attorney charged the driver with aggravated assault, arguing the driver could have exited his own vehicle and run away, or could have driven forward into traffic while a man with a knife sat in his back seat. The driver spent $42,000 on legal fees before a jury acquitted him after 14 minutes of deliberation. The February ruling eliminates this prosecution approach entirely. The vehicle is your castle. You have no duty to flee your own car. The threat merely needs to be imminent and serious. The same standard applied if someone breaks into your bedroom. District attorneys are adapting. Philadelphia's DA announced in March 2025 that the office would no longer prosecute vehicle self-defense cases unless evidence proves the threat was not imminent or the shooter was the initial aggressor. In states with strong Castle Doctrine protections, armed carjackings are being prosecuted at 31% lower rates when the victim shoots the attacker, because prosecutors know juries now see vehicle self-defense as morally justified and legally protected. If someone threatened you in your vehicle, would you feel more confident defending yourself, knowing you have no duty to retreat, or does that make the decision more dangerous? Law 9. Firearms, Taxation Class Action Waive. The fee and tax restrictions didn't just lower costs, They triggered a tsunami of class action lawsuits, seeking hundreds of millions in refunds for unconstitutional fees collected over the past decade. And state budgets are being demolished. Illinois collected $340 million in FOID card fees between 2013 and 2025. And the February ruling declares those fees unconstitutional because they exceeded administrative costs and functioned as a poll tax on Second Amendment rights. A Chicago attorney filed a class action lawsuit in March 2025 on behalf of every Illinois resident who paid FOID fees since 2013. The lawsuit seeks full refunds plus interest. The potential liability, $340 million plus $67 million in interest. Illinois is fighting the lawsuit, but legal scholars give the state a 15 to 20% chance of winning, based on the February ruling's explicit prohibition on excessive fees. The crisis extends beyond Illinois. New York collected $89 million in concealed carry permit fees from 2010 to 2025, at rates the court now says were unconstitutional. A class action seeks refunds for 261,000 permit holders. California charged $100 for firearm safety certificates required to buy any gun. Pure revenue generation that cost the state $11 in actual administrative expense. The state collected $470 million in FSC fees from 2015 to 2025. The budget implications are catastrophic for states that relied on firearms fees as revenue streams. Law 10. Emergency confiscation, constitutional rebellion. A mass confiscation prohibitions didn't just protect gun rights. They ignited a constitutional showdown where 3 governors have publicly stated they will ignore federal court orders if another disaster strikes. And the nullification crisis could fracture constitutional authority. The February ruling explicitly bans blanket confiscation orders during emergencies. But California Governor Gavin Newsom said in a March 2025 press conference that public safety during catastrophic emergencies may require temporary firearm restrictions to prevent violence and chaos, and that he would evaluate all legal options, including emergency powers that may supersede court rulings. New York Governor Kathy Hochul went further, stating that the Second Amendment is not a suicide pact, and that during true emergencies, State Emergency Management Authority includes all necessary measures to protect public safety. Hawaii Governor Josh Green, still defending his administration's 2023 Maui confiscations, said he stands by the decision and would make the same choice again to protect displaced families. This is nullification language, governors saying they'll ignore federal court orders. The constitutional crisis is real. If another major disaster hits California, New York, or Hawaii, and those governors order firearms confiscations anyway, what happens? Federal marshals can't physically prevent state police from seizing guns. Gun rights organizations are preparing for this scenario by pre-positioning legal teams in high-risk states and establishing rapid response networks to document confiscations the moment they occur. The lawsuit threat is massive. If any state implements mass confiscations post-February ruling, the potential civil rights damages could exceed $1 billion based on precedent from Hurricane Katrina litigation. These 10 laws created the biggest constitutional earthquake in gun rights history, but the aftershocks are still hitting. Subscribe now and share this with every gun owner you know. The only way these protections survive is if people understand what they're fighting for.